Hi, everyone. My name is Jane Kleb. I am with the Alliance, a group that has various projects all meant to help community protect their land and water, or an easement action team, or Bold, Nebraska, the group that we first started when we were working with farmers and ranchers against the Keystone XL pipeline. We welcome you tonight. We know some of you are here to learn more about carbon pipelines and the impulse that are trying to figure out the very using maze of where your authority begins and ends to protect landowners in your community. Or you may be a landowner who's concerned about what they're hearing at Summit or Navigator public sessions in their community meetings versus what you're reading online and questions that you may have. So we have a team of experts here tonight to talk about the basics of the carbon pipelines, what counties can and cannot do. And then we have two elected officials who are struggling with a lot of these questions right now that we're going to hear from as well. So first, I'm going to kick it off to Stephen Feit with the organization CIEL to give us a good overview of what exactly we're dealing with.
Thanks so much, Jane. And I want to start by sharing a video just for a little bit.
This video shows a buried dense phase carbon dioxide pipeline. The experiment was conducted in the safe environment of the DNVGL Spade Adam Testing and Research Centre to assess the consequences of such ruptures in terms of mass outflow, crater formation and dense gas dispersion. The viewer should note that the extent of the visible plume does not necessarily represent the extent of the dense gas hazard.
So hopefully you are all able to see that. I know it was a bit choppy at the beginning, but what that was a test explosion and release of dense phase carbon dioxide in a controlled facility that would simulate what it might be to have one of these carbon dioxide pipelines leak. So I want you to keep that in mind while I talk through the rest of this presentation. Okay. So thank you again for having me. My name is Stephen Feit. I'm an attorney at the Center for International Environmental Law, and I've been focusing on carbon capture and storage for a number of years now, and the threat that it poses to communities by the sites of capture, storage, and critically, for this conversation, transportation. So I want to start by just talking about what CCUS is. It's actually 5 processes. There's the capture of the carbon dioxide itself, where CO2 is removed from a gas stream, either pre or post combustion. Compression, where CO2 is pressurized into dense liquid or supercritical phase. So this is not the CO2 that you see in soda or beer. It's not the dry ice and smoke machines. This is carbon dioxide under enormous heat and pressure at much higher pressures than you have even in natural gas pipelines, for example. But that pressurized CO2 is then transported, usually via pipeline, to its final destination. And we'll get to this in a bit, but the locations of capture are often quite far away from the places where carbon can actually be utilized or potentially stored. And then the CO2 may be utilized. The only real market for CO2 is in enhanced oil recovery. And finally, stored, injected underground into deep saline aquifers, depleted oil and gas fields, or coal seams. Notably, many of the discussions of what CCS is exclude the transportation part, similar with EOR, but it really is one of the critical pieces of the process and the key to unlocking the build out anticipated and desired by proponents. So today I want to quickly cover what some of the issues are around carbon capture itself, some of the issues around storage, and then explain what we're looking at in terms of this pipeline build out. So capturing the carbon, you will see claims about what carbon capture can do. I think even that graphic that I just showed suggested 90% capture. You'll see industry proponents claim 95 or even higher percent capture. The reality is much, much starker. This good compilation by the Institute for Energy Economics and Financial Analysis shows a number of carbon capture projects profoundly missing capture targets. Some of them not even getting halfway there. You'll see the three, starting from the left, have two capture rates because the carbon capture process itself is so energy intensive that that running the carbon capture equipment itself releases enormous amounts of greenhouse gases. An analysis of the Texas-based Petronova project, a coal-fired power plant with carbon capture retrofit, ended up emitting a huge amount of CO2, you can see in this light blue bar, from a natural gas generator powering the carbon capture system, cutting into the relatively meager capture to begin with. This doesn't even contemplate the additional upstream emissions from either coal or gas that would be used to power the equipment. When you put all of it together, the life cycle impact and the ability of carbon capture to meaningfully reduce emissions is truly vanishingly small. The reason ethanol in particular is being targeted and why these pipelines are coming to the region is because ethanol is meant to be kind of the best case scenario other than gas processing for the actual application of carbon capture. It is thought to be about the second cheapest way to capture a ton of carbon dioxide. Having said that, there's one large scale carbon capture facility on an ethanol refinery in Illinois. And despite trying to really make it work, the Archer Daniels Midland plant is profoundly underperforming its performance goals. You can kind of see the whole boondoggle right here, that the whole $400+ million project, of which the lion's share came from the Department of Energy, has not been able to capture carbon at the rate it was supposed to. Again, you see this 95% claim. When you actually look at the EPA database that reports where ADM has to report their emissions, you see the 4.7 million tons per year before the carbon capture equipment was installed. It was actually installed in 2017. So I genuinely don't know the full details of this project, but it seems to be capturing less than 10% of total emissions. Finally, I want to just share that in addition to the greenhouse gas impacts of carbon capture equipment itself is highly polluting. This is from a permit application from Chevron Phillips Chemical Company for a steam cracker to make petrochemicals and plastics. And you can see that the additional energy penalty, that extra energy needed to run the carbon capture equipment, doesn't just add to the greenhouse gas load, but increases emissions of nitrous oxides, carbon monoxide, volatile organic compounds, PM10, sulfur dioxide, and ammonia. So this presents a profound public health risk in addition to the way it serves to entrench fossil fuels and the underlying emitting facilities. So that's on the capture side. On the storage side, I want to just really run through the relationship between carbon capture and oil production, because they are intimately and somewhat inextricably linked. There is no commercial market, of any meaningful scale for CO2 except enhanced oil recovery. So enhanced oil recovery is after a well has been more or less depleted, you can inject carbon dioxide. You can also, there are other ways to do it, but you can inject carbon dioxide and basically bubble out more oil. This is by far, you can see, so sorry, on the left is a list of commercial CCS facilities and projects. And if you look at that rightmost column, you can see the role of enhanced oil recovery in making the math work out. So more than 80% of CCS capacity globally is used for EOR. That's more than 95% in the United States. And most of the existing CCS is for gas separation, actually, not post-combustion capture, kind of what we think about for CCS at power plants. But this is not a mistake. This is very much the plan. 11 years ago, a group of organizations came together and industrial interests to try to promote policies to advance the use of CO2 and enhanced oil recovery, noting that the main barrier to taking advantage of CO2 EOR's potential has been an insufficient supply of affordable CO2. So this push for carbon capture deployment is in many ways as much about supplying a cheap and affordable source of CO2 for enhanced oil recovery as it is about actually capturing carbon or reducing emissions from these underlying facilities. But the key to all of this is the transportation. You can see this map. The facilities where carbon dioxide is emitted are not always near where the carbon could actually be injected underground. There's a huge mismatch between where the emissions are coming from and where they'd have to go. And what that would mean is a need for a massive pipeline system. There are a number of renderings. One from the Great Plains Institute shows what a near to medium term pipeline network could look like, built out across most of the United States, drawing CO2 from, you can see the ethanol refineries in yellow, ammonia in orange, and et cetera. Similarly, a massive study by Princeton showed what a national network could look like and how ubiquitous these pipelines would really be. You know, even if you yourself are not near an emitting facility for which carbon capture would be applied, these pipelines are going to run through a lot of communities. And the scale of this intended build out, it's hard to visualize, but you can kind of make a comparison to the current system that we have. This study, this Princeton CCS build out, just to sequester an amount equivalent to 15% of US emissions, would require infrastructure whose throughput volume would be higher than the volume of oil flowing through US distribution and refining pipelines. So we are talking about an enormous build out of pipelines through communities all across the country. And of course, where you have pipelines, you have leaks. You may or may not know about the story of the pipeline rupture in Satarsha, Mississippi, in Yazoo County, where over 300 people were evacuated and 45 treated at area hospitals after this pipeline ruptured. CO2 is not toxic in the way that oil or gas is, but it is an asphyxiant, right? That makes it dangerous in a much different way. And it's heavier than air, which means, as you may or may not have been able to see, I don't think the video necessarily played very well, but because it's heavier than air, it pools at low volumes. That means that if you're in a valley or low-lying area, the CO2 that leaks from pipelines has the potential to pool and present dangers for a considerable period of time. With that, I think I'm over time. So I'll just say thank you. And let me stop sharing. And yes, I see, I will be able to share slides and all of these resources for sure.
Thank you, Stephen. And we're going to get to questions at the end. And if my video gets choppy again, I apologize for that. Mark's going to take it over. I live in a rural community and sometimes the internet is not reliable. So apologies for that. I just want to underscore one point, that the maps that Stephen had put up, you know, right now there's about 5,000 miles of carbon capture pipelines, and the industry wants to make that up to 60,000, and in a very fast pace because they're trying to take the opportunity of these 45Q tax credits. So there's a lot of concern of a build out that quick with a lot of unknowns and not a lot of regulations, which is what our next speaker is going to talk about. Bill from the Pipeline Safety Trust is going to give us an overview about what's happening at the federal and state level as far as regulations. You know, our country's had 100 years to deal with oil and gas pipeline regulations, and even those aren't wonderful for landowners and local communities. But now these carbon pipelines are very new. So I'll turn it over to Bill.
Thanks, Jane. Yeah, my name is Bill Caram, and I am the Executive Director of the Pipeline Safety Trust. And we were formed in the aftermath of a 1999 pipeline tragedy here in Bellingham, Washington. A gasoline pipeline ruptured and spilled gasoline into the creek that runs through the middle of our town, and it eventually ignited, and it killed 3 boys. And the community and the family of those boys rallied and to try to do what they could to prevent tragedies like that from happening to another community. And so we were formed as a national watchdog on the pipeline industry and the regulators to try to prevent these tragedies from happening to other communities. And the more I learned about CO2 pipelines, the more I feel like this is exactly the type of issue that we were formed to work on. And so the Satarsha incident that Stephen referenced, when the story about that came out, that was really the first time we as an organization had thought much about CO2 pipelines. And then that was followed by the 1-2 punch of learning about the 45Q tax credits and the infrastructure bill right afterwards. And so we quickly got down to work to try to wrap our heads around the issue, figure out where the state of regulations were. And it was about that same time that Jane and Paul reached out to, and we decided to work on this white paper. So we'd really have something to work off of. So we commissioned that white paper, we released it in March, and it really highlighted some, enormous regulatory gaps. Some really basic regulations that would need to be in place for any kind of build out. And so some of those are, there's a very narrow definition of CO2 in the current regulations. And most, if not all right now, CO2 is being transported as a supercritical fluid. And that's as a distinct state. There's a gas and there's a liquid, and then there's this in between, this kind of supercritical fluid that has some properties of a gas and some properties of a liquid. And the current regulations only apply to CO2 if it's in that supercritical state. So if it is transported in any other way, it's not regulated at all. I would say one of the biggest things that came out of this report, the one that as a safety advocate keeps me up at night the most, is the lack of a proper process in the regulations for determining a potential impact area. So pipeline operators need to determine a potential impact area around a pipeline. And if their pipeline is determined to have the potential to harm a high consequence area, which often is a population center, they have to go through stricter safety standards on that pipeline. They have to apply more pressure tests. They have to work harder against corrosion, and they have all these extra safety standards that they don't have to do if the pipe is said to not have the potential to impact a population area. So what we found in that Satarsha incident is the operator, Denbury, had determined their potential impact area. and a lot of those folks that went to the hospital and were sickened by that pipeline were well outside of that potential impact area. Pipeline operators are used to just putting in a diameter, pressure of the pipeline, and then it spits out this 600 feet for a potential impact area. And because, as Stephen mentioned, CO2 is heavier than air, it can travel as a plume in these high concentrations in unpredictable ways. And so we need to really rethink in the regulations how we determine how big of an area this pipeline can really impact. And the paper points out that this could be measured in miles and not feet, that potential impact area. So we would love to see some process developed in the regulations about what models to use and when. There's no one size fits all, and so different terrain, different weather. These operators really need to use a kind of mosaic of models to come up with that potential impact area. Some other things we saw was the potential for this unique type of fracture in the pipeline called a running ductile fracture. When a rupture starts and the product goes through those phase changes, as you saw in the video Stephen posted, it moves between those three states very quickly, and it can lead to like an unzipping of the pipeline over a large distance in a really short amount of time, which can release a lot of CO2 all at once, and it can be a really violent rupture. And there are ways to mitigate against that, but right now operators aren't required to do that. So we'd like to see that in the regulations. Things as simple as adding an odorant to the line so that if there is a rupture, folks know there is CO2 in the air and I'm being asphyxiated right now and I need to get out of here. Those aren't required either. I mean, a lot of these were just crazy to us as we learned that these weren't already in the regulations. Something as like the level of contaminants in the product. What we saw in Satartia was there was H2S, hydrogen sulfide in that CO2. There's no regulation about setting a limit as to what the maximum amount is. And there's a lot of corrosive and toxic impurities that often travel along with CO2. And we need to see some standards set on where those levels need to be. And then there's just simple water. Water in a CO2 pipeline will form carbonic acid, and that is just incredibly corrosive at a very fast rate on steel pipelines. And and again, nowhere in the regulations is there a limit on how much water can be in the pipeline. We're also hearing on some of these projects around the country that operators are looking to repurpose existing infrastructure for CO2. There's nothing in the regulations about that. And it really poses a lot of unique risks with CO2 pipelines when we're talking about these high pressure lines. Repurposing a line that wasn't built for that is a pretty scary idea. And there's some voluntary advisory bulletins out there that don't deal with CO2 specifically, but there's really nothing in the regulations about what kind of standards a pipe would need to meet before it's repurposed for CO2. So you can find the paper on our website is pstrust.org. There's also a backgrounder on there that is more of a summary, and it gives all these recommendations as to what the regulations are. And so I encourage anybody to read that, reach out to us at any time if we can be helpful. I am encouraged. PHMSA, the federal regulator, has started a rulemaking process to deal with some of the issues we brought up in our report. I would just add to that, that's wonderful news. We're really excited about that, but the recent rules PHMSA has passed have been 10 and 11 years in the making. And once PHMSA passes a regulation that has to do with the design or construction of a pipeline, they're statutorily limited for that to only apply to new and replaced pipelines. So any of the pipe that's been installed up until those regulations are adopted, they cannot go back and tell an operator to bring them up to the new standards. And so we're trying to pursue every avenue we can to get these safety regulations in place. So thank you so much. And I'll be available for any questions.
Thank you, Bill. And definitely eye-opening. I knew that PHMSA had opened up some rulemaking, but I didn't know quite the length of time, as you described, as to what, I guess it should not be a surprise when the federal government's working through things to get that far. So that just underscores and puts an exclamation point a lot about then what can our counties and states potentially be doing in order to make sure that folks are kept safe, our land is protected, our water is protected. So with that, I'm going to turn this over to Paul Blackburn. He's going to give a presentation on what counties can and cannot do. I'll just say before I throw the mic over to Paul that, the pipeline companies come into our communities and say that all of the regulations at the federal level are perfectly fine to keep everybody safe, and that the counties essentially have no role in local ordinances, lawmaking. And that is not true. And Paul will go into the details, but you should really pay attention to the fact that these companies are telling you don't do anything. They're doing that so they don't have to pay any extra money, and they can try to build these pipelines as cheap and fast as possible in order to get those 45Q tax credits. And we're here to say that we live in these communities for the long haul. So we want, if any pipeline is going to be built, it to be super safe. And for some of these pipelines, we don't want them built at all. So with that, Paul's going to go through what you can and cannot do at the local level.
Hi, everybody. My name is Paul Blackburn, and I grew up in Mason City, Iowa. I wandered off to Washington, D.C. and worked in a premier energy law firm for a number of years. Decided I didn't like it so much and left. And for the last over a decade now, I've been working on pipeline regulation and hearings. I spent a lot of my life sitting around in hearing rooms in the Minnesota PUC, at the South Dakota PUC, Illinois Commerce Commission. I've been involved in DAPL, Sandpiper, Line 3, Keystone XL, probably some other ones I forget now. And in addition to that, I've done things like work on permitting coal-fired power plants, hydroelectric projects, and wind turbines. So I'm going to do a presentation to share my screen here. So let me get the presentation rolling. So bear with me here. Can you all see that?
Not yet, Paul.
Okay, let me.
And while Paul's getting that up, just a reminder, if you have a question, you can type it into the chat or into the Q&A little bubble on the bottom of your screen.
Let me try it this way. Sorry about that. Can you see this? I don't know why it's not working, but I'm not able to get, I can't see where it's.
Oh, there it goes.
Okay.
We're now seeing your beautiful nature screen.
Okay. All right. So again, my talk is on county regulation of carbon pipelines. And let me just start by saying that there's basically 3 areas of law we need to be concerned with here. One is the Pipeline Safety Act. It's a federal law. It regulates pipeline safety standards. Now, safety standards are particular things. You know, the industry tends to come and say anything related to safety is preempted by federal law. Well, that's not true. They have a particular definition, and if it's outside of the definition of safety in terms of federal law, then it isn't regulated by the Pipeline Safety Act. There's also state laws at issue. And I can't go into all those because it's state specific, but it includes things like home rule laws, zoning laws, pipeline permitting, and there's different judicial and court cases too, like the preemption doctrine. And the state's going to have a very wide range of authority that they allow court counties to exercise. Then there's also the Federal Natural Gas Act, and it regulates interstate natural gas pipelines. We're not going to be talking about it here, but sometimes the industry tries to confuse folks with talking about, they refer to an interstate natural gas pipeline, and those are regulated almost exclusively by the federal government, but that's because of a different law, the Natural Gas Act. Interstate carbon pipelines and oil pipelines are not regulated by the Natural Gas Act because they're not natural gas facilities, but they are regulated by the Federal Pipeline Safety Act. So let's talk about the Pipeline Safety Act here. Okay, the safety standards that it discusses are for the design, installation, inspection, emergency plans and procedures, testing, construction, extension, operation, replacement, and maintenance of pipeline facilities. That sounds comprehensive, but it actually isn't, and we'll talk about that more.
Sorry to interrupt you. The only thing we're seeing on the screen is a yellow kind of picture of a beautiful flower.
Yeah, thank you for.
Yes.
Yeah, let me see how I can do this.
Now we're starting to see him on the bottom.
Yeah, I need to. Well,
there we go. Beautiful.
Okay. Yeah, when I do the slideshow, it changes things. Anyway, I'll just do it this way.
Okay.
So yeah, so that's the so anyway, the Pipeline Safety Act has these three parts you need to think about. One is the safety standards. It's in part 60102A. Then there's the federal preemption piece. That's in 60104C, and it says a state authority may not adopt or continue to enforce safety standards for interstate pipeline facilities or interstate pipeline transportation. But then there's also 104E, and it states this chapter does not authorize the Secretary of Transportation to prescribe location or routing of a pipeline facility. So that means that there's a routing carve-out, a routing and location carve-out, that the federal government regulates safety standards, but it doesn't regulate where a pipeline goes. So if you think about federal safety standards, they're kind of like a building code. And just like there's building code and zoning laws, the building code says how you build something, how a pipeline is designed, how it's inspected, how it's operated, what's maintained, and how a pipeline operator responds to emergencies. But that's very different from like the zoning requirements. So, a zoning law could say whether a building should be built in a place or not, but it doesn't say how that building is supposed to be built. But anything that counties do related to how a pipeline is built or maintained or operated is preempted. But it doesn't regulate all safety things. For example, the counties have their own emergency response capacities. The Federal Pipeline Safety Act does not federalize local response to pipeline ruptures. That's still up to the pipelines. Even though emergency response is a safety issue, that's not covered by the Federal Pipeline Safety Act. The Federal Pipeline Safety Act does regulate how an operator responds to emergency facilities, emergency ruptures and things, but it doesn't regulate how the county is going to respond to that rupture. So again, just think about the Federal Pipeline Safety Act as a building code. But then, like I said, location and routing is regulated by the states because federal law says that the federal government can't determine the location or route of a crude oil or a carbon pipeline. So again, state and local governments have sort of a zoning type jurisdiction over pipelines. They get to say where it goes and even if it's built. And where an interstate pipeline is just not a federal issue. So many states have pipeline routing and siting laws. For example, Iowa, Illinois, Minnesota, North Dakota. And they've issued and controlled pipeline route for decades. There's no doubt in law. There's no question whatsoever that states can regulate route. And in some states, like in South Dakota, it doesn't regulate route, and therefore it's up to the counties. Even some states that have state regulation, it may be up to the counties. We'll talk about that later. In terms of setbacks, we hear a lot of arguments about whether the federal government regulates pipeline setbacks, and it simply doesn't. And in fact, that's because the federal government, Pipeline Safety Act itself, says that the federal government can control routing or location of a pipeline. And the setback has to do with location. So therefore, if the federal agency, if the PHMSA tried to control where a pipeline goes, it would be violating federal law. And therefore it doesn't, it can't. It's simply illogical for people to admit that a state can route a pipeline and then say, but the federal government preempts because it can preempt a setback. If the state can decide where a pipeline goes, whether it's 10 feet from a house or 100 feet from a house or 300 feet from a house, it doesn't really matter what the federal government says, because the federal government can't say where that pipeline is going to go. And this was expressly decided in the court case. This is the Fifth Circuit Court of Appeals. This is down in Texas. This is not a court that's like, in California or something. This is in Texas. They're very sensitive to oil industry down there. The Texas Administrative Decision expressly considered the issue of whether a city could do a setback, and they said it was okay. This is a 2010 decision. There just simply is no question that federal government or the state and local governments can issue a setback. Now, the reason that there's confusion, and I wrote a blog post on this, is that there was an old regulation from 1981 that's still in the books that makes it sound like the federal government can control route and location of a pipeline. But that provision in the statute where Congress said the government can't regulate route or location was enacted in 1994. Well, newer laws, by Congress preempt old regulations by an agency. And again, this was exactly what, discussed in Texas Midstream. And, and they just said, a regulation promulgated by an administrative agency cannot expand the unambiguously expressed preemptive scope set by Congress. Meaning if the Congress said this is not a federal issue, the agency can't infringe on states' rights there. And then the section B there, it says that no pipeline may be located within 50 feet of any private dwelling or any industrial building without another foot of soil on top, essentially. That's not a setback. It's written like a setback, but it's not. A setback says you can't build it here. This says you can build it within 50 feet or further than 50 feet. If you build it closer than 50 feet, you have to add another foot of dirt on top. Again, this is a depth of cover requirement. This is not a setback. If it was a setback, it would just say you can't build within 50 feet, period. And it doesn't say that. It doesn't say that. It says if you do, put another foot of dirt on top. And the reason they add another foot of dirt is so that in theory it adds some more safety. But the federal government can't say you can't build it within 50 feet because that's a location issue. Now, federal case law on this is quite clear. There's been some more recent cases on this issue. The Washington Gaslight case out of Maryland, a county said, no, you can't put a facility in this location at all. And the company sued, and the court said, it's clear that county zoning plans are primarily local land use regulations as opposed to safety regulations. It was very clear. This is the Fourth Circuit Court of Appeals. Texas Midstream, I already talked about that. That was looking at a whole variety of things, everything from setbacks to the color of the brick in the buildings and other things like that. And, they said they couldn't put in safety fences. That was a security fences. That's a safety issue. But all the other city regulations were upheld by the court there. And then Portland Pipeline Corporation's Portland, Maine. The city there said, we don't want a new oil terminal here. And it was affected the Pipeline Safety Act. And the court there just said, that even though the city considered safety when determining whether they should have a pipeline terminal there, that consideration of safety was not sufficient to convert a ban on a loading crude oil facility into a safety standard under the Pipeline Safety Act. These court decisions are very clear about this, and we're getting clearer all the time. So, and here's the thing about safety and routing. Since the federal government can't look at a route and say, oh, there's a hospital here, or, oh, there's an explosive factory here, or, oh, there's a nursing home here, and therefore we're not going to put, the pipeline here. The federal government can't make that decision, can't determine routing. That means that if a state or county government can't do that also, then no agency can consider what's the safest route of a pipeline and pick the safest route. And that's the federal government, the federal law on preemption generally does not favor regulatory gaps. Doesn't say, well, the feds can't do it, then the states shouldn't be able to do it either, or local counties can't do it. Somebody has to be able to say this pipeline shouldn't be able to go near a school, and that somebody is the state or the county. And so they have to be able to consider safety and routing, just like the Portland Pipeline Corporation case said. So, and there's other things that counties can do. Counties can issue mitigation rules, and this depends on state law and what the state says. In Iowa, there's more complications. In other states, the counties have more say. But I can send you reams of permits that include everything on mitigation, from what kind of seeds should be planted to, what kind of lift should be done for the soil and segregation of soil, and so a double lift or a triple lift, or and what kinds of mitigation needs to be done for making sure that cattle aren't trapped in the wrong place, or whatever. There's many things, because none of those things relate to how a pipeline is built or constructed. The federal government doesn't care what kind of grass goes over the right of way. They just don't. It's not a safety issue. The federal government does care about having trees be planted in the right way, because that makes it hard to inspect. So there's some gray area here, but it's very clear, and there's plenty of permits out there written by state governments and county governments that could, that have mitigation provisions in them. And then pipeline abandonment. The Pipeline Safety Act applies only to pipelines that are, quote, used or intended to be used in transporting hazardous liquid, unquote. That means that if a pipeline is no longer used or intended to be used, in other words, it's abandoned, then it's no longer within federal jurisdiction. The federal safety rules are there to keep product inside pipelines, right? Stop ruptures. If a pipeline is abandoned and there's nothing in it, and it's not pumping, there's no reason for the federal regulations to apply anymore to it. So there are federal abandonment regulations, but those regulations do is define the endpoint at which a pipeline is no longer regulated. So a company has to typically seal off the pipe, purge it, separate from other pipes, purge it of all kinds of flammable materials, and then seal it up. And then tell the federal government they've stopped using it. As soon as they do that, it's no longer an active operating pipeline, and therefore it's no longer subject to federal regulation. And so therefore it's just steel in the ground. It becomes a piece of personal property that's been abandoned. And for example, Minnesota has now imposed requirements on the abandonment of Line 3 and new Line 3. Eventually, we're doing a trust fund docket right now, and nobody sued on that. Nobody sued it. Enbridge didn't sue because they can't. So you'll hear, the companies come in and say, oh, the federal government has pipeline abandonment regulations. Well, those regulations apply to only the point at which it stops working. And after that point, once it's no longer operating, the statute no longer applies, therefore the regulations no longer apply. Okay, and then the federal emergency response. And this is really important, because these pipelines have, as we talked about already, have a fairly large and extensive area around which the CO2 could go out and asphyxiate or intoxicate people. And the question is, who can respond in an emergency way? Well, counties can't tell the company what to do with their own staff or how they're going to respond. But what counties can regulate is their own emergency responders, and they need to do that for their own emergency responder safety, and they need to do it for their citizen safety too. So, the Federal Pipeline Safety Act does not federalize local response. The federal government, in fact, the laws expressly say that a a pipeline operator has to cooperate with local officials, meaning federal law anticipates that, you know, the state and local response will be independent of federal response, but it needs to be coordinated. So, you know, counties need to do this. Now, counties can require a pipeline company to share information. For example, a county could order a pipeline company to do the computer modeling necessary to determine that impact zone that Bill was talking about. You know, that's not telling them how to respond in an emergency. It's just saying to the pipeline company, you tell us what the risk is, because it's your pipeline. You need to tell us what the risk is. And then we'll know how to educate our first responders about that risk. But again, you know, you can't tell the pipeline company what to do with its personnel in an emergency, but you can get information from the pipeline company so you can keep your citizens safe and so you can keep your first responders safe. So now, state preemption of county authority, this is a much bigger topic. Every state is different in terms of what the states and the counties do. In Illinois, for example, it's a very strong home rule state. And unless a state law expressly says that the county action is preempted, the counties have authority. And in fact, county action can actually preempt state law. It's really quite a remarkable situation in Illinois. In Iowa, it's balanced in a certain way. In Minnesota, state law says if it's under this routing law, that all county action is preempted. In Nebraska, the courts would consider whether there's a preemption or not, but since Nebraska has no laws related to carbon pipelines, counties are free. There's no state laws to preempt county law, or county ordinances in Nebraska. Counties can do what they want in Nebraska. In North and South Dakota, it's quite similar. The counties can take different actions as they see fit under their zoning rules. But then the Public Service Commission in North Dakota, Public Utility Commission in South Dakota can supersede the county's decisions, but both those agencies have to determine that the county's actions were, quote, unreasonably restrictive. So if the county in South Dakota and North Dakota is imposing reasonable restrictions on a pipeline, then by law, the state should support those reasonable restrictions and incorporate them into the state permits, or just accept that those are there. So, you know, again, it depends. But and I'll just finally say, since we're running out of time here, if you have questions, you know, just ask Bold Nebraska or Bold Alliance. You know, just ask us. We hear a lot of people with questions about this. You know, if you need competing memos, legal memos, just ask. If you need specific advice about whether a particular regulation or ordinance is appropriate for county to do, just ask. You know, if you rely on the companies, they're all going to say you have no authority. And unfortunately, sometimes the county attorneys who are involved in these cases don't have any experience with the Pipeline Safety Act and don't have any background in this area of law, which is somewhat complex. And so Bold Alliance is really here to help you figure this out if you want our help. So just ask. And again, thank you for listening today. And if you need to contact me, there's my email, and I appreciate your time.
Thanks, Paul. And we'll get to, I see a lot of good questions in the chat, so keep them coming. We're going to get to those in just a few minutes. First, going to introduce one South Dakota County Commissioner and then an Iowa County Supervisor. Both are joining us to give their own personal experiences about what their county is currently doing around carbon pipelines and what they're struggling with. So I'm going to have South Dakota Commissioner Feit first kind of describe what's happening in McPherson County, since there's been a hotbed of landowner engagement in your county.
For sure, yeah. I'm Sid Feit from Long Lake, South Dakota. I'm on the McPherson County Commission. And Paul Blackburn, thank you. You did shed a lot of light on some hope there, I guess is what I would have to say. But I'll just give you the rundown of how we kind of learned about Summit, and it's all new to us. We first heard of Summit. I first heard of Summit, and the commission basically first heard of Summit in October of 2021. At our December regular meeting, a Summit rep was on the county agenda for the first time. And then, of course, December is when we really started hearing from landowners. At our January 4th regular meeting, we had around 50 landowners show up. and very concerned about the whole thing. They had surveyors basically trespassing on their land and really without permission. And they kind of wanted to know what we could do. Well, we talked it over, and being the zoning board is a separate board from the county commission. They were already working on completely rewriting the zoning ordinances and in a new zoning book. And we had already, the McPherson County had already put a moratorium on a wind farm that was to go in possibly in northern McPherson County. So we thought a moratorium on this pipeline would be the right thing to do, being there was no zoning whatsoever for any pipelines, let alone pipelines carrying hazardous materials. So on January 11th, the zoning board met, and they imposed a moratorium on pipelines carrying hazardous materials. And then later that same day, our McPherson County Commission met and voted in support of the zoning board's decision. And then on February 1st, we only meet once a month. We usually meet the first Tuesday of each month. And lately we've been having a few more meetings, and partly because of this pipeline. But on February 1st at our meeting, summit officials were on the agenda, and we were told there that we needed to stay in our lane. Kind of take that for what take it for what it may be. We've kind of felt like he was just telling us that they were going to come in and do whatever they wanted. And then on April 5th, and there was meetings in between, but on April 5th at our commission meeting, a Summit Carbon Pipeline permitting department was there. Three gentlemen from the permitting department were there, and they wanted to know, wanted to get all the information on our zoning, which we had a moratorium on. We're in the process, and it takes time to rewrite zoning ordinances, obviously. And we really couldn't give them any answers. They wanted to know who the contact people would be for which would be our county highway superintendent. But I guess to me, it was get the PUC permit first, then come see us. And that's kind of where it's been left. We are in the process also of enacting a resolution opposing the Summit Carbon Pipeline. But besides our regular meetings, I've been to a meeting in Millette, South Dakota, 2 in Redfield. One was a PUC meeting, PUC meeting in Aberdeen, at least 4 in Leola besides our commission meetings. And the ones in Leola have been kind of amazing. The residents have just, local landowners have just kind of come out of the woodwork. It's kind of amazing, and really a poor time of the year to be going to PUC meetings and everything with calving and planting and everything else. But a lot of people took a lot of time out of their schedules and spent, a major amount of time getting to these meetings. And I guess just to kind of give you a little bit of an idea of where this pipeline runs, I believe it's 58 miles through McPherson County, and kind of comes in on the southeastern corner and kind of exits north central McPherson County. And then Leola is kind of east centrally located, and 5 miles west of Leola, they are proposing to put in a compressor station. The elevation difference between 5 miles west of Leola and Leola is 270 feet. It is higher. This compressor station will be higher by 270 feet from Leola. Leola is about 430 to 450 people. But if there's a leak and it hugs the ground or it's heavier than air, where's it going? That's one of my biggest concerns. I have a son and a daughter and 2 grandchildren living in Leola, and I don't want to see anything happen there. Prevailing winds are from the northwest. And if this pipeline's under 2,100 pounds of pressure, boy, that just seems wild to me. And then CO2 released into the air supposedly expands over 500 times in square footage as a gas. Sounds like it could be a big problem. safety wise. And then one thing that's really kind of come up in the last probably 6 weeks here is land value. What's it actually going to do to the land value and the assessed value and everything? I know the local landowners around here, if this pipeline would go in, it would definitely hurt land sales, at least for those landowners maybe buying a piece of neighbor's ground. What's it going to do to assessed value? It's all questions we have no idea. How's it going to affect the revenue for the school systems in the county and townships? They came in, Summit came in with, I'm sure you've all seen it, with numbers for tax revenue that each county would be receiving. And McPherson County's was kind of off the charts high. If you believe in too good to be true, I'm pretty much positive that's what that is. And we did find out back in 2007, 2008, we had a wind farm go in northern McPherson County. We had 59 towers go up, and we were going to have a pretty good windfall of tax revenue. And the state of South Dakota managed to get their hands on that money, and eventually we got some of it back, but it was just a fraction of what we were promised to begin with. So who's to say this won't happen again? All things that cross our minds. And I guess that's kind of all I have. It's just really concerning to all the landowners and how it's going to slice through. We've had surveying crews literally trespassing on landowners' land and gotten reported to the sheriff. And I don't know exactly where all those, what all ended up with some of that stuff. Some just happened here in the last week. They just come in, seems like they're just kind of running roughshod over us. And it's a very, very frustrating. And like I said before, the amount of time that we've spent learning about this and just burning gas to get to the meetings, and it's just kind of been unbelievable. So with that, I'll pass it on.
Thanks, Sid. Thanks for standing up. I've got to hear you at one of those meetings, stand up for the landowners in your community. So I deeply appreciate it. Next, I'll pass the mic to Iowa Supervisor Kinkle from Shelby County. Oh, Supervisor, you're on mute.
Thank you. And my name is Steve Kinkle. I'm Shelby County Supervisor, Southwest Iowa. Been a supervisor for 10 years. And yeah, Sid, I can relate. The only thing I'm a little envious of is you said Summit came to you. We had to invite Summit to come to our board meeting, and they've only been there once that we invited him to. We first heard about him through our landowners getting their certified letters that this was happening. My email and phone started ringing off the hook. What's going on? I will say that one thing I've been the most disappointed with in our state is I feel this is flawed. It's the only type of project I'm aware of where there's no local control. There's no public hearings. There's no local board of supervisors input. When we have windmills, we have solar farms, we have animal confinements, they all come through the board, the supervisors, and making sure the regulations are met. Public hearings, the public gets an input, and we vote whether the public is for this or not. Landowners get to decide where these structures are put. This is the only one that's not. And I have yet to have anybody tell me why that's the case here, and it doesn't serve that public purpose. So when we first heard about it, the first thing we did as a board was we filed an objection with the Iowa Utility Board solely based off of eminent domain use. We feel it's up to the landowners to decide whether they want it or not, and they shouldn't lose that right if that doesn't happen. Then we went and amended, and if there's any county supervisors out there from Iowa, listen to this. Do this the first thing. We amended our utility permit construction permit for right-of-ways. That is one of the only main things that you can do as a county, because it says in Iowa code under the eminent domain that the county, along with the railroad and the Department of Transportation, the state, they have to get approval to cross our roads. And they do not have authority to give condemnation or the use of eminent domain. So you need to be updating your permit to include hazardous pipelines and making sure they follow what you want them to follow. And I can't stress that enough. And since that, we passed that about March, and now we're working on a draft ordinance for hazardous pipelines in the county. I wish we could just go, it's kind of, this reminds me a little bit of COVID, where you can't go grab it off the shelf, that book, and see what we need to do, and because it just seems to be kind of overwhelming that we're missing something or missing several things. So I appreciated Paul's insight on a lot of things there. But another thing, I'm also a 5th-generation century farmer, so I value the land out there. And this pipeline in my area, my county, is just a mile west of me. Well, if we don't fight this now and get it the way we like it to, I could be the next one, because we hear there's 2 more right behind this coming. And one thing I'm really concerned with from being a farmer is compaction and yield loss. And I don't know if any of you have seen, Iowa State did a study on Dakota Access Pipeline, and we're trying to get that included in the docket with the Iowa Utility Board on how it affects yield. And I would like to see, they're trying to measure it by rut depth. I have a huge problem with 12-inch ruts, let alone if they're 6 or 3-inch ruts, and the compaction it can cause. And so we're trying to see if we can come up with a tool, like a saturation measurement tool or something like that, that is be easy to use and not destroy something before we say, no, this isn't enough. You know, I'm sure a lot of you are aware of all the costs to the counties, not just hiring an inspector, but all the digital data you need to have in place, because we have to call in. I don't know what the other states do, but if there's a, we have to put a compensation board in if eminent domain comes in, so we can get fair market value, any of the damages at the end of the project. Who's going to pay for all this? Is it going to be the same landowners who their land gets taken away from them and he didn't want this? And then we see our property tax go. We had Summit come in here just a month or so ago and give an economic impact, kind of like Sid said, the numbers were way up there. But I also contacted, and I had our assessor contact the Iowa Department of Revenue, who sets those tax bases, and they weren't even contacted yet by Summit. So how they could come up with this estimate, I don't know. It is an estimate. And you have to remember, if the counties are doing all this work and we might have to hire extra people, I don't know about your county or your state, but here the county only receives 27% of the tax valuations in our county. So even though we're doing 100% of the work, the schools are going to get 52% of the taxes. So this is all over the place. I would advise, I just had a conversation today with our State Farm Bureau. I'm sure Sid does too. Landowners come up to you, community people come up to you, people live in the towns come up to you. What can we do? I've since put them towards our legislators, but they need to be contacting their farm bureaus, because I don't know about the farm bureaus in your state, but the Farm Bureau here has been, and I'm a Farm Bureau member, have been very, very quiet. And you need to be asking them, are you out supporting my property rights? Are you out there just helping me keep out, I'm going to say, the strangers of endangering our countryside? You know, what are you doing to protect us? And I really mean that. I mean, they need to be asking those questions, because I feel like we're out here all by ourselves, and I know the landowners do. And Sid, I don't know about you, but in our county, we rely all on property taxes. And
Absolutely.
to me, it's a team effort here. We have to be there for them just as they expect us to do our job. And yeah, I guess I'll stop at that. I appreciate the invitation here to speak. There's a lot to be learned, and there's a lot we have to do to stay together here. Thank you.
Thank you so much, Commissioner and Supervisor, for joining us today. You're
Hi,
absolutely
can I-
right. Yeah,
Can
go
I
ahead.
add a couple things?
Yeah,
From what I understand, you either can't get insurance on this strip of land. Landowners have, checked into it, or it's gonna be so high that nobody can even afford to pay it. And we also sent a letter of opposing this pipeline to the South Dakota PUC. And I think that's been a really big thing to party status with PUC. From what I understand, this pipeline has gotten more party status requests to the PUC than any other issue they've ever had in history. So that's saying something too. And there is a lot of opposition to it. It's really a interesting subject and frustrating subject also. So.
amen. And there's so much more. I mean, we do these webinars once a month, and I feel like every time we do it, it could be a 3 or a 4 hour just on that one particular topic. So there's a lot, and that's the reason why we all exist and why the easement action teams exist, is so landowners can be sharing information with one another. The companies love to isolate counties. They love to isolate landowners so they can essentially get their project in the ground for the cheapest way that they can. That's their bottom line. And so we're going to take some questions and then I'm going to obviously ask everybody here. These slides and presentations will be on the Bold Alliance and the Pipeline Fighters website, so everybody else can see them as well. But first, let me ask a question from Kathleen Campbell, who asked kind of a series of 3 questions. They're all related to regulations on the county level. She asked if a county imposes setbacks, is it the county's responsibility then to identify a viable pipeline route to meet those setbacks? Paul, do you maybe want to take this, because it will differ by state if a state has a PUC or a PSC that's approving or altering a route. And just a heads up for Nebraskans that are watching, Nebraska has no state review since our Public Service Commission says they have no authority over carbon pipelines. So we are in essentially twilight zone area for Nebraska in particular. So Paul.
So which state was the question from again?
She does not list her state.
Okay, yeah, the question of setbacks, and the issue here is if you set too big of a setback, like from a residential property, there might not be any viable route. And so, the issue of how to handle a setback practically is going to require a little bit of specific analysis for a particular state. But also, they're probably going to need to be conditions like putting halfway between residences. And if it is closer to a residence than a certain distance, then there needs to be things like carbon dioxide, detectors. Everybody knows like monoxide detectors in their house. Well, you can buy on Amazon a carbon dioxide detector. And should the company have to pay for that? And, as Bill said, it could be odorized so that people can smell it. And there can be automatic call systems, kind of the alert through your phones or text systems that could be in place if it goes closer to a house than a certain distance. So yeah, the county's going to have to work out that, and we can help with drafting, but they can set a general setback, and then there can be conditions if it can't go through. The problem with having a setback that is too extreme is you can essentially zone out a pipeline, and then you can get into other kinds of conflicts. For example, with interstate commerce clause of the U.S. Constitution. A county, it's generally risky to just simply say 100% no to a pipeline going anywhere through the county, but it can impose a lot of restrictions on where and how to keep people safe.
And that actually dovetails into her second part of the question. Because I know some counties do major setbacks for wind, which essentially zone out wind in some counties, like they do mile setbacks, et cetera. And so that essentially becomes a moratorium on wind. Is it she's asking, is it possible that a county imposes a moratorium? Or can you just describe that? Because I know that that's fairly impossible, but there's other things that a county can do.
Yeah, I think that, again, there's a risk that if a county just said no to an interstate pipeline, carbon pipeline, then the carbon pipeline developer would bring a suit in federal court on the interstate commerce clause. And that clause essentially says that states and local governments can't unreasonably restrict interstate commerce. So, so it depends on whether a court would say that it's an unreasonable restriction or not. So you do get into a bit of a risk there if you just simply say no to it. The reason it's not as big an issue with wind farms is that they're not necessarily interstate facilities. They may be connected to the grid, but they're a local, state regulated entity. But these pipelines go from state to state and are moving a product, CO2, between states. So they're regulated a bit differently.
This one's on safety. And so Bill, you may also want to answer this one, that if a county can require a company to share safety information to the first responders, can it also require that safety information needed is what safety information is needed to determine setbacks if a county's struggling with what type of setbacks to do? And can a county require that the company pay for all these extra emergency response costs, including electric vehicles? And I think that's a reference to the cars in Mississippi not starting because of the way that it was affecting the engines.
Yeah, I'm actually not sure on the county's authority or abilities there. Paul, if you're able to answer that.
Yeah. Again, Federal Pipeline Safety Act prohibits counties from telling pipeline companies how to build their pipelines or how to run their pipelines, or how the county's responders are how the company's responders are going to respond to emergency. But the Pipeline Safety Act doesn't say anything about how local county should regulate its own first responders. That's county's business. So yeah, and for example, things like, could a county require that the pipeline company do what's called plume dispersion modeling, computer modeling? And sure, a county could require that a company do that modeling to determine what the impact area is and pay for it and then tell the county. Because again, telling them to do a model doesn't tell them how to build the pipeline. It doesn't tell them how to operate the pipeline. It doesn't tell them how to maintain it. It just says, if we're going to keep our county first responders safe, we need to know what the danger zone is for these pipelines. And so, and you're the pipeline owner. You need to tell us what that information is. And could a county then require they pay for that study and also pay for equipment and pay for first responder training? Sure, because again, ordering a pipeline company to pay for first responder training doesn't tell them how to run their pipeline. It just says you need to pay us county to handle this risk, and we need to make sure our first responders are safe. And the pipeline company should pay for that, so that it's not coming out of taxpayers' pockets. So yeah, again, the Pipeline Safety Act regulates how the company runs its pipelines, doesn't regulate how the county responds to emergencies.
One of the things I remember from Keystone XL in an emergency response paper you did, you talked about how a county could regulate even a trailer of equipment being purchased and placed inside the county, since a lot of us live in rural counties. And if sometimes the company's trailers of equipment would be like in the big city of that state, and it would take hours to actually get that emergency response equipment. So that's one other thing too that I remember you training us on before.
Although it's a bit different, and that may not apply here. And the reason for that is that was for an oil pipeline. And there's another federal law called the Oil Pollution Act that lets counties manage emergency response for oil spills. But there is no federal law about spills of CO2, of supercritical CO2. there's just no, it's such an unregulated area that there really isn't any emergency response laws set up for these pipelines at all. There isn't anything federal and there isn't anything state, and there usually isn't anything county. So it really is up to the counties to do this. You know, the only emergency response requirements that exist at this point is the requirement in federal law that that pipeline companies have a plan to manage their own employees in a response. And, you know, again, you can get the Source Valley Pipeline emergency response plan in North Dakota offline. It's available online. You can look at it and see what they did. And they don't, all it does in that plan is talk about how the pipeline company's employees are going to respond. Doesn't say anything about how anybody else is going to respond. And they only equip their own employees. That's all they do. So as long as you don't mess with their regulation or their management of their own employees, you know, counties can require pipeline companies to give them information, pay for things, and pay for and get equipment for the county.
Perfect. We had actually a landowner meeting today in Holt County, and this question about property taxes and how much taxes a pipeline company will pay the county came up, and this came up on other pipeline fights as well. These corporations throw out all these big numbers, not only for taxes that they're going to pay, but also the number of people that they're going to employ, which is always exaggerated because they use a Chamber of Commerce multiplier factor, not the actual employees. So this question is coming from Shelley, and she wants to know, you know, what is going on with the taxes? And is it going to be 1.5 million a year? Is it going to be 1.5 million forever? Like, what is the bottom line with the taxes? Is it property tax, or is it a different kind of tax that they pay? Paul, I think this one, I'm sorry for all these questions to be thrown, but Paul, I think this one is for you because you've written a paper.
Well, I say that one of the big implications for the taxes is that, remember, this whole process is driven by the 45Q tax credit, by a federal program. They only have 12 years under federal law to get that tax credit. So what happens to these pipelines after 12 years? Now, this is like in the Summit Pipeline, it's a $4.5 billion piece of infrastructure with a 12-year life. You know, that's a pretty remarkable situation if you think about it. That means that in theory, they're going to have to pay off all their capital expenditures in 12 years. But then, you know, what happens at the end of the 12 years? And does that mean taxes only last 12 years? You know, that's just a big question. I mean, with an oil pipeline, you can expect taxes to last maybe for a couple decades or longer, but these are just a short time. Another thing about the taxes in Minnesota, most people don't know that Enbridge is sued in court, in tax court, and got a property tax cut because they said their pipeline wasn't making as much money as they expected it to. Now, in other states, the law may be different, but essentially the way it works in Minnesota, the way the courts decided to work, is that the property tax is determined by the ability of a pipeline to generate money. So if something goes wrong and that pipeline's not generating as much money as they expect, at least in Minnesota, you know, they argued and won that the pipeline would be devalued in terms of its property value. Now, other states may or may not be able to do that, but that suggests that if something goes wrong with the Summit deal after they build it and is not generating as much money as they thought it would, then the property taxes may be significantly less than they're predicting. So again, you get the length of time, we're not sure about that. And we're not sure about how this valuation is going to work for such a short-lived asset where it's all driven by federal tax credits. And we don't know how much money it's really going to make over time. The federal government could just go bankrupt at some point, and then what would happen?
And to be clear, the taxes that they're paying to the county is on the actual pipeline, which the pipeline piece of equipment, which depreciates every year, which means the taxes that they would pay to the county every year go down as well. Did you hear that, Paul? I just wanted to.
Yeah, I wasn't sure of the question. Yeah, the property taxes, again, if it's a 12-year life on an asset and they're not sure it's going to last past that long, then you'd assume they'd have a 12-year depreciation. You know, how that plays out in taxes, I'm not a tax law expert, but, you know, these are all questions that the county should be looking into because, you know, this could all go belly up And then what happens?
I think the way to look at this pipeline would be, it would be like a structure. Your property taxes on a structure, I guess. I know there's some questions coming in and they're almost looking like a personal property, like a tractor. But I would think like your buildings on your farm, they have an assessed value. Pipeline's gonna be similar, and that's what they're gonna be basing the property tax on that they're paying. But I think it's kind of interesting that this all comes up because I mentioned earlier that in 2007 and 8, they built 59 wind towers on northern McPherson County. And McPherson County and the school district and everything was promised a lot, pretty big sum of money and of revenue. And state of South Dakota kind of tapped into that, took most of it right away. And then I think kind of graduated it back in to where, the revenue was increased over time. But, you think about it, that wind tower project was supposed to be a 20-year project. Okay, 2007, we're at 2022, that's 15 years ago. Well, now we're starting to talk about tearing them down and taking them out. My point is 12 years in the grand scheme of things is just nothing. It just goes so fast. Anybody who has kids, it's just such of a short-term project to be spending this kind of money and affecting so many people's property and lives. It kind of blows my mind that something like this would even be proposed.
That's right. And especially because most states, Minnesota's probably the exception, most states don't have strong pipeline abandonment laws in place. So with a lot of the wind turbines, counties or states have passed laws that require very specific ways in a timeline on how a wind turbine is decommissioned and taken down and the land restored. That is not the case on pipelines. And so we have some pipelines in America, for example, been running, 60, 70 years. And while Summit and Navigator have said their pipelines may have a 25-year life of service, they could then sell that easement because these easements are forever. Unlike a wind turbine, they have to pay landowners every month. These are permanent easements that they pay a landowner only once, and they could convert from, let's say they're going to pump carbon in it this year or for the next 5 years because it's profitable with the 45Q tax credits. But if those go away, they could then convert it to another product. So there's some states that would forbid that, some states that don't, and a lot of risk and concerns for counties and landowners at the local level. Paul, related to that, because you mentioned something about taxes on 12 years from now. And so I think there was a little bit of confusion. So somebody's asking, is that 12 years from now, or is it 12 years from the start of an individual project? But I think combined with that, if you could remind folks that the 45Q tax credits actually have to be reauthorized by Congress every so often. So let's talk about that, because that could not get reauthorized, and then these projects would be in a serious world of hurt.
Yeah, the 45Q tax credit, it's 12 years from the date of start of operation. So now most of these companies, and I'm just about to release a whole series of blogs on the 45Q tax credit and how it works. But most of these companies are shooting to start operations in 2027 because that's when the 45Q tax credit hits its maximum amount. And so they started operation, for example, on January 1, 2027. They would continue operation for the next 12 years after that. Now, I think that under federal law, in theory, they have a right to that tax credit for 12 years then, and whether or not Congress authorizes it, sort of. But we're talking the federal government here, and we're talking, potentially, seriously, hundreds of billions of dollars going into this tax credit. And, if you trust the federal government to not go bankrupt in the next 10 years, 12 years, then, or after that, then maybe it makes sense. But, if there isn't money there, you can't get blood out of a turnip, right? So there could be a legal right to get the tax credit, but Congress might just have to yank that right back if they don't have the money to pay for it. It's a lot of money. It's a lot of money these tax credits are at stake here. So I hope that answers the question. It's 12 years from the date of the start of operation, but that's in theory that the federal government has the money to provide that kind of tax credit for that long.
And it's also in theory, just so I'm correct, that for projects that haven't been built yet, if the 45Q tax credits don't get reauthorized, I believe the next time they're up for reauthorization is in another 2 years, then these pipeline projects that are being proposed wouldn't financially be possible.
Yeah, it depends on, how the federal reenactment works. But, so far, there's been a lot of political pressure to get these 45Q tax credits back in place. That may not last forever, in part because, as Stephen was talking about, there's a link here with the oil industry, and the oil industry wants to get free CO2 paid for gratis from the federal government to do what they're going to do with it. And that's why they've been passing. But I think if more and more people are concerned about this and about how much money it is and about the potential budget impacts, it's, a big federal pork program. And I think we're all concerned about where the country goes, given the massive amounts of deficits that are out there already.
Yep, that's right. We'll ask one last question and then I'll throw it out to everybody in case something came up and you want to say some closing remarks, because we're about 3 minutes from our close time. So the last question is, can an Illinois county require that a pipeline company cover any liability insurance that the pipeline itself precludes from affected landowners? Because we do know in the contracts, Paul, you know this, that it's very not clear language, which is why landowners that are trying to protect their land then go get liability insurance, which some of them can't even get access to now.
Well, the state, again, liability insurance doesn't say anything about how a pipeline is, physically operated, maintained, designed, or anything else. And the state of Minnesota imposed very, very clear insurance requirements on Enbridge Line 3, for example. They didn't get sued. So it isn't preempted by federal law. So I would imagine that an Illinois county could require some sort of financial assurance instrument to make sure that if there is a rupture or other kinds of damage done by the pipeline, that there would be insurance in place to require that, or a bond of some sort. And in fact, the state of Minnesota just finished its first round of comments on a financial abandonment plan for Line 3. But Enbridge also files annual reports on their insurance. So, and Minnesota even require what's called a parental guarantee. We don't know how these companies are structured, who actually owns them, and who has money to pay if there's a problem. And we need to figure that out. And there needs to be a very broad guarantee from all the different entities that are involved in these pipelines to make sure there's cash available, so they just don't, declare bankruptcy in a problem and walk away.
That's right. So I want to say we didn't get to all the questions, and so I will volunteer Paul to answer some of these because they're very specific for questions that Paul can answer that we can include in the email out to folks when we email out the video over the next couple of days. So if your question didn't get an answer, I promise we will include an answer in the email that we send to folks who are watching this. And I'm just going to go down the line and ask folks to give a 30-second closing with any words that you want to leave folks who are watching the webinar. And I will start with Sid.
Okay. Yeah, no, thanks for putting this on and including me. I very interested in what Paul had to say on what the counties do have the right to do. Yeah, I can relate with the Iowa commissioner. He's fifth generation. I am also, and we also have the pipeline running within a couple miles of our place here, and just a big concern. And thank you.
Thanks, Sid. And we'll go to the Iowa supervisor, Steve.
I just have a kind of a personal question. I've been thinking about this. We all know what's going on over in Ukraine, and we all know about terrorists. But is there some safety feature if this thing goes through, where it's pumped in that cavern up in North Dakota, that what happens if that entry is bombed? Is there like a shut-off valve way down in the ground, or does that whole area have to take all this? And what happens? I mean, I'm just thinking generations out, are they going to look back at us and say, what were they thinking or not thinking? And I'll close with that. Thanks for inviting me.
Thanks, Steve. And Steven.
Thanks, Jane. I just, there's so much to talk about on this subject, but I want to maybe reiterate some of the questions around the funny math and the financing, that this is not with the exception of using CO2 to pump more oil, it's not a self-sustaining or profit-making enterprise. And it's entirely dependent on the 45Q tax credit, or particularly for ethanol, also factoring into the low carbon fuel standard in California. And we've seen, whether it's Kemper, whether it's Petro, the list of failed capture projects is long. It's longer than the list of successful ones. And in particular, if the CO2 is used for EOR, it's then pegged to the price of oil. And so if oil isn't expensive, if the price of oil drops too much, those facilities just may simply not run.
Exactly. Bill.
Yeah, I just want to thank you, Jane, for putting this together. And it's a really wonderful resource for the counties that are being asked to shoulder this burden of risk of the folks you represent. I'm really heartened to see how seriously you are all taking it, and my hat's off to all of you. If I can be any kind of resource on the safety issues, please don't hesitate to reach out. And thanks again for the opportunity to share our perspective.
Thanks, Bill. The Pipeline Safety Trust is the premier nonprofit out there on pipeline safety. So definitely take Bill up on his offer. And Paul.
The last thing I'd say is that, the pipeline companies essentially threaten to sue counties if they do something that they don't agree with. And my response to that is, well, let them. I mean, because, the word, if at a minimum, and you could just simply let them sue and then just say, okay, well, we'll change it if you want to, or you can fight them. But I think this is where, if all the counties are together and they have good legal advice going into it, the chances of them suing a lot of these issues are slim to none, because their lawyers might be willing to say all kinds of things to you in meetings, but they're not going to be able to make specious arguments to judges. They're not going to be able to do specious arguments in court filings. They're going to have to, really put their cards on the table. So, you can push the envelope, you can just be conservative about it even, and do things that they don't want you to do. And then if they sue, then you can deal with it. But again, just like the landowners that we have, the easement action teams, I'd suggest that counties start talking to each other about how to work together as a team, how to fund this so you don't have to come out of your county budget in case something like a suit comes up, and so you can defend your rights, because they just like to threaten people with suits, but that doesn't mean they're going to win. And again, I've given you 3 cases, there's others out there, that expressly showed when the industry sued, they lost. They lost. Clearly and unequivocally, they lost. So, don't worry about being sued so much. You can deal with that if it happens, but I don't think they're as likely to sue as they say they are.
Thanks, Paul. And I want to thank everybody for tuning in today. We will send this webinar link around to the folks who signed up on Zoom, but we'll also post it on the Bold Alliance and the Pipeline Fighters Hub. I want to thank Mark Hefflinger for all the work that he does to make sure Zooms like this happen and that they're promoted and that we continue to educate the public. And I'll close with just saying something that we believe when it comes to these carbon pipelines: no climate solution should put communities at risk and should take land by eminent domain. If it's a climate solution meant for the common good, it should be doing good, not taking land away from people and not putting communities at risk. And so we're going to use all of our resources to make sure that landowners' property rights are protected, that all the tribes that are also fighting these pipelines, their sovereign rights are protected, and that counties are not left holding the bag for these risky pipelines. So thank you, everybody, for joining, and we will see you on the next webinar.
Thank you.
Thank you.
Thanks.